Production funding for With All Deliberate Speed is provided in part by membership contributions to Friends of LPB.
Prior to desegregation also, Negro children had to walk to go to school in the mud, in the rain, and everything else. Well, Negro children were riding as far as 18 miles to come to a Central Negro high school.
For the past 3 decades, school boards around the country have struggled with the process of school desegregation. Of the 25 oldest court cases still pending in the federal court system, 9 deal with school desegregation. 6 of them are in Louisiana. The idea of equality was an integral part of the Declaration of Independence. But by the time of Reconstruction, some laws sanctioned equality only in separate facilities. On June 9, 1892, New Orleans resident Homer Plessy set out to challenge one of those laws. Plessy, 1/8 Negro, took a first-class seat in the white section aboard a car of the East Louisiana Railroad. His arrest became the basis for the Supreme Court's landmark decision in Plessy v. Ferguson. In 1896, the court ruled against Plessy. 90 years later, his grave in New Orleans lies neglected and forgotten, but his case does not. It became the basis for the doctrine of separate but equal that would dominate society for more than 60 years. The only justice to side with Plessy in the case was Justice John Marshall Harlan, whose grandson would one day sit on the court that would reverse the Plessy decision. In 1954, several plaintiffs had suits before the Supreme Court seeking equality in the public schools. Future Justice Thurgood Marshall argued the case. On May 17th, under Chief Justice Earl Warren, the court gave its historic decision in Brown versus the Board of Topeka. All 9 men ruled that in the field of public education, the doctrine of separate but equal has no place, that separate facilities were inherently unequal. 1 year later, it ordered public schools to desegregate and to allow admission of students without racial discrimination. The process was to take effect, they said, with all deliberate speed. The wording would leave the process open to interpretation by school boards and district courts.
The all deliberate speed, we did not think meant 28 years.
Why did it take so much time to even accomplish what we've accomplished? Well, the Supreme Court understood that when in 1955 they used the words all deliberate speed.
Segregation is just as important to maintain in this country as our free enterprise system, our national economy, our national defense, the preservation of the people, without which there can be no preservation of our country.
The South of 1954 was almost totally segregated. Much of that was law. A great deal was custom. To Louisiana's white leaders, maintaining segregation was more than preserving a way of life. It was essential to the strength of America.
We had an idea that the communists were behind this thing. We began to get a hold of the communist publications, the NAACP publications, the Negro magazines and newspapers in the United States, and we began to put this thing together.
When the Brown decision came down in 1954, whites in the South reacted with anger. For blacks, the decision signaled the promise of equality in education.
But we can never underestimate or discount that victory. Nothing else has happened in the black community for the positive good of the nation. Elimination of separate accommodations, of segregation in restrooms and in swimming pools, where none of that, in my judgment, could have happened but for that landmark decision in 1954. At that point in history, the death knell for segregation was sounded.
Well, the morning I got the call on May 17, 1954, which I believe you all have described as Black Monday, I thought it was the coming of the kingdom we'd been promised in biblical history. And as I lived through it, I saw fears on the part of a number of people, both black and white. Blacks were afraid of losing jobs and taking a lower station from that to which they had built over a great many years. And I think whites were just simply afraid of change.
Despite optimism, the wall of separate but equal would not fall without a struggle. In 1955, the Supreme Court followed up the first Brown decision with an order that the public schools should desegregate with all deliberate speed. The court knew the change would not happen overnight, but they relied on school authorities to act in good faith. That faith proved to be premature.
and it was couched in very broad terms. It obviously contemplated a gradual desegregation. That is, to desegregate with all deliberate speed. Now, all deliberate speed can mean all things to all persons, and intransigent judges, federal judges, interpreted it to mean that they could desegregate perhaps a grade at a time, and perhaps only with respect to individuals applying to enter to a particular school. Well, that would have meant a generation of continued segregation.
Louisiana officials felt that state law would protect them from the effects of the Brown decision. In 1954, the legislature invoked police power of the state to preserve a dual system in the schools. They also formed a joint legislative committee on segregation. Over the next 10 years, lawmakers would pass 135 bills aimed at maintaining the status quo.
What you're voting on here is whether or not your children, my children, and the children of all these people here are going to go to segregated public schools in the future, or whether we're going to have integrated schools. I want to remind the members of this committee that a vote for these amendments is a vote to destroy our registration and election laws. It is a vote to destroy segregation in the state of Louisiana. It is a vote against your own children and the future prosperity of the state of Louisiana.
Just to give you an example of one bill that prohibited the interracial athletics in the LSU stadium and prohibited the interracial spectators in the stadium. That shows you to the extent of how ridiculous some of those bills were.
Former State Senator J.D.W. served from 1956 to 1960. During that time, he often found himself a minority of one when voting against segregationist bills.
I felt like a pig going to the slaughter, having been raised on a farm, and the only thing I could do is squeal, because I felt like that it was, even though that I was expressing my viewpoint, that I wasn't going to change anybody's mind about the bills at that particular time.
1957. Events elsewhere draw the nation's attention. Arkansas Governor Orville Phobos called up the state's National Guard to prevent 9 black children from entering Central High School in Little Rock. President Eisenhower responded by federalizing the Guard to ensure the students' safe attendance. Through all of the tension, the lesson was clear. A mandate from the Supreme Court superseded the wishes of the state when it came to equal protection. The lesson was lost on lawmakers in the Deep South state of Louisiana. In 1960, country singer Jimmy Davis was elected governor for a second time, running on a platform that promised to maintain segregation.
When the Davis administration came into office in 1960, they were committed to the cause of state rights. And maybe I should put it, they were committed to the cause to do something, because the people were all upset, and they wanted something defined. They wanted their rights, their civil rights, as well as everybody's civil rights defined.
The test for Davis came almost as soon as he took office. The Orleans Parish School Board was under a court order to submit a plan by May for desegregating its schools.
In 1955, when the Supreme Court handed down the Brown II decision, I told the board that this was now the law of the land, and all that they could do would be to proceed to desegregate the schools with all deliberate speed. And I was prepared to attempt to get for them as much time as was necessary to effect an orderly transition from separate but equal to desegregated.
Despite the board's refusal to submit a plan, federal Judge Skelly Wright issued his own order. Black children would be admitted to white schools in September of 1960.
When the decree came down, it polarized opinions. Those people who might have been inclined to be liberal suddenly had to cast their lot. You were either going to go with the establishment with the whites, or you're going to go ahead and lend your support to the tide of the blacks for what they were looking for. And I think you have to understand that a lot of the people conceived of no other existence other than segregation.
People of Louisiana felt that they had a right to freedom of choice, that they had a right to determine their own destiny, which was the very reason that this country was founded. And here was their right those particular rights were being taken away from them. And they were naturally aroused, because if the government could do that, then they'd go further.
Throughout that summer, Louisiana tried to call off the order by filing motions for delay and even obtaining an injunction from the state Supreme Court. Each move was struck down by Judge Wright or a special three-judge panel.
There was a reaction, and most of the legal techniques, any historian or any legal scholar would have told you that these doctrines that they had invoked, interposition, for example, this doctrine had been knocked down by George Washington during the Whiskey Rebellion. You had some of the same catchwords, some of the same words that had been used in the Civil War when they tried to justify, for example, slavery as a right of private property and the determination of the states. You had the same arguments. You had states' rights, constitutional government. And the idea, everything revolved around the 10th Amendment to the Constitution. And the 10th Amendment provides that all of the powers which are not specifically delegated to the federal government are reserved to the states.
The board special attorney resigned. They now had no counsel and no plan. Judge Wright granted an extension until November 14th, but the extension also gave state officials time to react. Education Superintendent Shelby Jackson declared November 14th a school holiday, and Governor Davis called a special session for November 5th. In 5 days, the legislature passed 29 laws aimed at keeping the schools segregated.
Well, I felt that if we had closed our schools on November the 14th, we would never have opened them. So I told the governor, I said, no, you may think we work for the state, and you may think that we have to take orders from you, but I said, we are not going to close the schools on November the 14th. They are going to stay open. He said he would see that they wouldn't stay open, and implied that he would send the state police down to New Orleans to see that the principals closed the schools. Well, we got back to New Orleans Saturday night, and they immediately met with the other two school board members, and we decided that they agreed with me that yes, we would keep the schools open. We notified Shelby Jackson that we were going to keep the schools open, and I believe we sent telegrams, but we may have communicated in another way, but I think we sent telegrams to each one of the principals of all of the schools in Orleans Parish, telling them that on the threat of losing their job, that they had to keep the schools open on November the 14th.
In 1960, the legislature authorized the governor in an act to close the schools if he felt that the continued operation of the schools as they were could result in force, violence, and it was a result of that statute that Governor Davis actually took control of the schools in Orleans Parish.
I would bring in the picture here A.P. Turo, Dan Bird, and of course Thurgood Marshall and Judge Skelly Wright. Every day our job was to collect the bills that were being passed that day and race them down to A.P. Turo. And that evening Judge Wright would stay in his office, and those things were ruled unconstitutional as fast as they could put. And we were getting the key officials cited for contempt of court and that sort of thing through that period, but 5 special sessions of the legislature.
The state was officially enjoined from enforcing their laws. Desegregation in New Orleans would proceed as ordered. The school board used a computer to select 4 girls who would integrate McDonough 19 and France Elementary.
I was told the Friday before the Monday had happened to be a school holiday. The superintendent called the principal of the other school and me out to the warehouse. And the board attorney was there and the federal attorney, and said, this is where it's going to happen on Monday morning. Don't tell anybody. Just get there early.
Well, there was an enormous crowd of reporters from all over the world. Some of them I'd seen pictures of, some of them I'd known, and I'd known their writings. I thought, my goodness, this is really a world event. Of course, we knew that it was, but we didn't expect anyone else to know it because so few people paid any attention to things like that.
The shouting and whatnot would occur when the youngsters were brought to school by the federal marshals, or when they were taken home in the evening by the federal marshals. Or with all due respect, whenever a TV camera showed up, but the rest of the time was more picnic-like than anything else.
Although persons have a right to demonstrate peacefully on our streets, I have to take into consideration the fact that others who are opposed to the thinking of such demonstrators also have the right to freedom of movement and full protection of the law.
Crowds outside the two schools became a common scene, one that was played out on television and newspapers around the country. At France, where just one black girl attended, some white parents chose to keep their children in school. Their action resulted in harassment.
Brielle, why did you quit your job?
Oh, I'd say mostly pressure being put on a little at a time around the place there. The way they've been acting towards me, they won't have nothing to say to me. So I don't find a job soon. I just have to get out of the state because the way things are going right now, they're trying to make it hard for me, but like my wife and I talked about this way before, if this ever should happen to us, that we knew what to expect. If it went this way and it looked like it's going this way, that nobody wants to have nothing to do with us. But as far as I'm concerned, it makes no difference to me one way or the other, what they think.
At McDonough 19, a complete boycott of the school lasted all year, but the school remained open with 3 black girls as its only students.
And you took your boy out the first day?
Oh, I didn't send him Monday.
Oh, you didn't send him at all?
Governor Davis set a holiday, and I did abide by him. He is the governor of the state, and I did abide by him.
Are they still taking it all right after these last 3 days into this 4th day?
Yes, Mama. Fine.
Are you all determined for your children to stay in the school?
Yes.
Determined to stick to it?
Yes.
Before going, we were prepped, you know. They told us, like my mom and dad, they told us that not to be afraid, you know, that it was going to be different. They made us understand this. And I can remember the marshals coming to the house, picking us up. We were well guarded, okay. And riding to the school, it wasn't very far. And then just a whole crowd of people in the street yelling and hollering. What they were yelling, I don't remember. Okay, I can remember going into school. It was a crowded school with kids then, but we sat in the office for some time, you know, and then they escorted us to classes. But during the day, the rest of the kids, they left.
You can't hardly have discipline problems with 3 ordinary little girls, you know. So they come to school and do what we asked them to do. And we really didn't want to subject them to the crowds during the day, so we, you know, maybe in the middle of the afternoon or something, we'd take them out in the yard, but their playtime was pretty much inside the building. No reason to take them over in this side yard here and have the crowds just start yelling and screaming again. Didn't need that.
Much of the hostility was never witnessed by the public, and it was not confined to just the parents and children at the 2 schools. Many citizens blamed officials for causing the situation.
And they sent reporters to stay with me 24 hours a day. They went to my office and worked with me and stayed in the house at night. But the one that stayed with me at night, the one thing he wouldn't do was he would not get in my automobile in the morning until I had started it first.
I can remember that I was pushed out in the street in front of some traffic once. And after that, I didn't walk on the curb side of the street. I walked along the buildings. And I had, during the upheaval from the school case, the public school case, I was well taken care of. I had marshals in my home 24 hours a day, and I was taken back and forth to the courthouse during that time.
The remainder of the school year continued with talk of defiance still coming from Baton Rouge. The legislature held 4 more special sessions and tried to cut off funds to the Orleans board. But the schools stayed open, and token integration had come to New Orleans.
2 schools that were selected, both Ninth Ward schools, both in neighborhoods that considered themselves hardworking, medium, low, middle income neighborhoods, good people. I think they felt they were being dumped on. Why wasn't Silk Stocking area of the city touched?
I did not feel that the legislature would go as far as it did go, nor did I feel that the governor would go as far as he went. Yet, after a while, it was perfectly clear that they were influenced by the people who composed the White Citizens Council, and they were determined that the schools would not be desegregated, and those people, I think, would have preferred for the public schools to close completely.
As I came to these problems, I had no particular moral convictions. I was just another Southern guy who didn't give it a lot of thought, I guess. But as you begin to enforce the law and attempt to rationalize and justify in your own mind for your own satisfaction what you do, it became clear to me that not only was it legal, but it was also right.
Governor Davis made a pledge in his campaign to preserve segregation legally, without violence, without bloodshed. I think if he would have abandoned that particular position, I think if he would have told the citizens of the United States and the citizens of Louisiana, give up hope, it's all over, bow to these particular dictates of the federal court, I don't think he would have been governor very long. I just think that that was the mood at the time.
Oh, if I had another child and had to go through it, I'd go through it again. Okay. Just like we said, our tax helped pay the school too. See? They couldn't stop us from going after they tell us to go.
I had no intention. The thought never crossed my mind that I should do anything but do what I was doing because it was right.
In 1961, the Justice Department under new President John F. Kennedy entered the case to ensure that court orders would be carried out. As in Little Rock, federal law preserving equal protection had survived the test.
We had a struggle about this about 100 years ago, and in my judgment, it came out quite clearly afterwards that we were one union and that one state, one group could not break away and not follow the laws of the United States. When the court gives an order, it must be followed. We might not like it, might not approve of it, but it must be followed if this country is going to mean anything.
The boycotts and protests continued in New Orleans for the next few years as many white students left the system. State officials finally gave in to the court orders, but resistance to school desegregation in Louisiana was just beginning.
I, John J. McKithen, do solemnly swear that I will support the Constitution and laws of the United States and the Constitution and laws of this state.
When John McKithen took over as governor in 1964, it was called a new day for Louisiana. District judges had begun ruling against parish systems, but in ordering remedies, they still seized on the term all deliberate speed. For most school systems, that meant all deliberate delay. The judges were still looking for more direction from the higher courts.
I think that generally speaking, since this was an unfamiliar area, since many of the district judges at the time were schooled in something else, that it was a new concept. Many of the district judges had difficulty in lending enthusiastic support to this effort. I think that being close to the people, much closer to the people in the courts of appeal, I think it was logical that happened.
The original responsibility was put on the school boards, but they, of course, were not going to act. And they weren't going to act because they could not afford to lose the support of the community. So even in cases where they were in favor of desegregation, the school boards wanted a court order because it took the monkey off their backs.
By the time Congress passed the 1964 Civil Rights Act, only about 2% of black children in the 11 southern states were attending integrated schools. Louisiana ranked near the bottom of that group. Washington was threatening to cut off funds to systems that failed to comply with the new law, and civil rights lawyers saw the legislation as a viable tool in their legal efforts. Louis Berry was one of those lawyers. He returned to Louisiana hoping to find a different state than the one he left in 1957.
It was at that time when the Congress had passed the 1964 Civil Rights Statutes. I then made up my mind to return home because I felt that the legal weapons that were needed to actually carry on a viable fight had not been enacted by the Congress. I returned here in 1965 and found out that the status quo had not changed, that everything here was still biracial, including the school systems, including the places of public accommodation.
Freedom of choice plans had become popular for most school districts under court order because so few children of either race elected to change schools. The pressure to maintain racial separation was still strong in most communities.
And by freedom of choice, it meant that the people in those grades, the students in those grades, could choose any school in the parish. And in 1967, under that total freedom of choice, any student could choose any school. But we had 14 pupils out of some 30,000 to avail themselves of that choice.
If you have free to go anywhere you want to, what more can you ask? The thing that happened is that it didn't achieve anything practically in the way of integration. It didn't improve the lot of the black student. I think the Court of Appeals assumed the role of pushing this reluctance and became more activist, if you wish, to achieve this. And they did, and in some instances, it's my own belief too, that they overdid it.
No other group of judges in the country did more during the mid-60s to change the face of school desegregation than the U.S. Fifth Circuit Court of Appeals. They were charged with handling appeals of cases in 7 southern states. In essence, their role was one of fleshing out the mandate contained in the phrase, all deliberate speed.
The Fifth Circuit really led the fight throughout the nation. And the judges of the Fifth Circuit were so highly respected that the Supreme Court just didn't second-guess them. They didn't grant writs in any of their cases for a period of 7, 8, or 9 years.
I have never thought that I was head of the Supreme Court. I thought, I've always expressed it as fleshing out the bare bones of a mandate from the Supreme Court. Deciding what the Supreme Court would have decided had it focused on the particular issue before me.
Judge John Minor Wisdom wrote several important opinions by the Fifth Circuit, including the landmark Jefferson case in 1966. He called for the use of federal guidelines throughout the 7 states. Judge Wisdom's decision is regarded by many as one of the 4 most important opinions in the history of school desegregation.
Jefferson imposed on the school districts the affirmative duty to root out the old system. I said lock, stock, and barrel. The Supreme Court picked up the language and paraphrased it and said root it out, root and branch. The idea is the same. I think by that, certainly we had come to that attitude after a large number of cases, that it had to be done on a district-wide basis. And that meant not just admitting individuals to individual schools, but doing away with the old system and instituting a new system.
I think that they pretty well accomplished what they set out to do, and no one can ever question the motives and the ideals of these men on the Fifth Circuit who really kept the district judges in line as to what should be done.
By 1967, desegregation in most of Louisiana was still token, yet it was still an issue in Governor McKithen's campaign for re-election.
The matter of actual record, Louisiana has less integration in its public schools than any other state in the South. That's an actual record. Now, those who are for integration, of course, will be unhappy, and those who are for segregation can take perhaps some relief in that. We haven't given up. We're just doing everything that the best minds we have in this state know to do.
Following the lead of the Fifth Circuit, the Supreme Court in 1968 handed down the Green decision that laid to rest freedom of choice as a tool to achieve a unitary system.
The Green decision said that freedom of choice was out. And the reason that freedom of choice was out was because freedom of choice had not worked in these areas in which it had been utilized. Because no white children had asked in these two particular school districts to be transferred to schools that were predominantly black. And as a result of that, you still had all black schools. So the Supreme Court said freedom of choice didn't work, think of something else.
By the late 60s, social tension over civil rights reached a peak. Blacks were more vocal in their desire for equality now. In Louisiana, they staged a freedom march from Bogalusa to Baton Rouge. Southern politicians felt they were losing more and more power to the federal government. To many, the chief culprits were the federal judges.
1954, the precedent and the law have been repeatedly broken. We find the federal judiciary sitting as a continual constitutional convention, changing and altering the law from day to day, and informing the nation that the Constitution is only what they say it is. Of course, our Constitution is disappearing. We are no longer governed by law. We are governed by men. The lawlessness emanating from these lawless edicts now stalk in our streets, riot in our cities, intimidate our Congress, and threaten the very order of our civilization.
We cannot allow the opposition of a community or a state to affect our judgment calls. We are bound by the Constitution as we see it and by the Supreme Court decisions as they come down to us. And while we are necessarily affected by being part of the world too, we cannot allow opposition of say a majority group in society to affect our judgment.
After they buried freedom of choice, the Supreme Court in 1969 went even further by calling for the end of all deliberate speed. The case was Alexander versus Holmes County. It ordered several districts across the South to fully desegregate in midterm. Parents and public officials could no longer hold back their anger.
To be free was the real reason that this country was founded. And in the last 100 years or so, we've been on the back grade. We're losing all of our freedoms. And unless we stand up and let the Washington government know that we want to be free, we will surely lose every bit of our freedom.
We're tired of being used as guinea pigs down here. We demand that the hypocritical judges and legislators in Washington do away with freedom of choice in Washington and the surrounding area and on all other parts of these United States of America if they're going to see it done here. We demand that our universities be treated like all other universities. If there is to be amalgamation here, let there be amalgamation there.
Education leaders from around the state met in January of 1970 to discuss ways to meet the court's mandate and still maintain stability in the schools.
We are determined to preserve public education and move this state forward. We're not going to sit idly by, and just because the Supreme Court has ruled the way we didn't want it to rule, some of us didn't want it to rule, maybe a majority of us didn't. We're not going to let some of those people in Washington or some of these people at home destroy a public education system that this year is over 100 years old.
The time has come when we must all pull together to save and improve as best we can our public school systems and to see that they are operated within the framework of the law. The courts have no expertise in the operation of school systems, as I believe has been amply demonstrated over the past 15 years.
Sectionalism once again reared its head, and Louisiana's leaders were determined not to go down without a fight. The issue of forced integration became a top priority for the McKithen administration during 1970, as the governor tried to get his views heard in Washington and the rest of the country.
The following is an interview with Governor John J. McKithen of Louisiana.
Ladies and gentlemen, I know you're wondering what the governor of Louisiana is doing on your television screen at this time. I've come here to ask you to help us in our state. We're facing in Louisiana the gravest crisis we've ever faced in my lifetime. It has to do with our public schools.
I felt, and I've said many times, and I feel now, that forced integration is just as unconstitutional as forced segregation.
I took the position that segregation was wrong. It was not America, although many of us had been guilty of practicing it either by being white, acquiescing in it, the great majority just acquiescing in it. It wasn't America. There was no way to defend it under our Constitution, and there isn't. But I said only the same thing of forcing an integration thing was equally unconstitutional, I thought, un-American. That was my thrust, generally my thrust.
That imposed upon us through the insistence of the HEW, the United States government, with the help of the federal judiciary.
For McKithen and other Southern leaders, their only hope seemed to rest with a sympathetic administration in Washington.
This problem of race relations, and particularly with regard to segregation in our schools, is not a sectional problem. It's a national problem. It should be handled in a national way. I have no patience with those from the North that point the finger at the South and then overlook the fact that in many northern cities and northern states, the problem may also be a very, very difficult one.
In a few short months, the Supreme Court would make a decision that would galvanize public opinion on forced integration. Using a case in North Carolina, the court laid out specific guidelines to be followed by district courts in desegregation cases. In Swan v. Charlotte-Mecklenburg, the court was now saying that systems were obligated to remove all vestiges of state-imposed or de jure segregation. But the language used became easily adaptable to both sides in a desegregation battle.
It was a decision of the court that had a little bit in it for everybody. It was, I think, they unanimously concurred in the result, but for different reasons. You had several different opinions by members of the Supreme Court, and plaintiffs, the government, and I are all cite Swan against one another for because of some of the things it says.
Busing, rather than integration, became the focal point of resistance that would mark the decade of the 70s. The faithful yellow animal had suddenly become the villain.
Well, I think busing is unfair for everyone concerned. The extra time that is spent with the children in the bus should be spent in the classrooms.
What would you do about it?
Well, I'm afraid I'd have to stand up and say they couldn't be bused.
If your children are assigned to buses, assigned to another school, what would you do?
I'll stand in front of the school. They will not go on a bus to another school out of our present districts.
Busing is nothing more than a problem coming from segregated housing. As long as we have segregated housing, if we're going to have desegregated schools, then we have to have busing. It's largely a boogie thing anyway, because over 50% of the children in the country are bused to schools just regardless of desegregation. In many situations, parents holler for busing. They want busing. They don't want to be bused quite often for desegregation purposes.
With the coming of forced integration, busing became a local and a national political issue.
But what doesn't work, and the evidence I think is clear of this, is these forced orders to take 6-year-olds for an hour and 15 minutes in one direction.
The Supreme Court says busing may be used as a remedy. It's really the remedy of last resort.
The demagogues have made of busing a very blinding social issue. It's really not the bus, it's us. It's really a racial issue.
We have never decided busing is the way, the only way, and this is what we shall pursue. However, as we have looked at the national level, the state, and the local levels, as we have looked at other options, nothing seems to achieve that racial balance, that unitary system, and that's what the balance is all about, a single system.
Of Louisiana's 66 parishes, Rapides, in the heart of the state, has had the most extensive busing plan. 2 decades of desegregation have been marked by tension and defiance. Emotions flared against Judge Noman Scott's 1971 busing plan.
Busing is certainly one of the main tools. There's no way, for instance, that I can integrate a school in the black or the white area without, if they are in areas which are black or white, as opposed to a mixed area, which there are not very many of, without busing.
At one point, national attention focused on 3 girls and State Judge Dick Lee as they openly defied Scott's busing order. The Buckeye Three, as they came to be called, and Judge Lee became local heroes, while Scott and the plaintiffs became the object of the community's furor and hostility.
I don't try to escape it at all. I think that's part of the technique, if you want to call it that. I think it helps to have a shot at that SOB.
I received a number of public threats over telephone. So did Reverend Sylvester Valley, in which I would get anonymous phone calls, and I'd be cursed out and told that you're going to be killed, or something's going to happen to you. You better leave these schools alone. And